There has been a very, very alarming recent trend, headed, of course, by the Attorney General, who speaks on behalf of the executive, who in his various statements, and I'll only identify three of them for the present purposes, has been trespassing upon the exclusive purview of the judiciary. We notice his most unfortunate comments in the case involving the teachers' union, in which the Honorable Justice Kissoon presided, in which the language that was used by the Attorney General to describe not only the decision, but the judge was completely unacceptable. If you found discomfort in the language, the actual trespass to the founding principle of separation of powers between the judiciary, the legislative, and the executive is even more alarming. In that case, and subsequent cases, as I'll identify, the Attorney General took it upon himself to threaten the judiciary by using language that made it clear not only the displeasure of the executive with the outcome of a case, and that's perfectly normal, but effectively to suggest that the Honorable Justice Kissoon, whose decision he described as vacuous, was not fit to be a judge. That we consider most egregious. This was then followed more recently in the case in which there was an application by Konoko, where the Honorable Attorney General again took umbrage at the statements of the judge. And rather than saying that he was going to appeal or attempting to criticize it from an academic perspective, he personally attacked the judge. This is beyond coincidence. And then most recently, we had the most unfortunate statement coming from the Vice President in relation to current proceedings taking place before a sitting magistrate in a very hotly contested issue, the prosecution of the elections cases. The statements by the Vice President, apart from their intemperance, indicated clearly the fact that the executive thought that it is appropriate, while a case is being heard, for a non-professional person, i.e. a non-lawyer, to comment during the proceedings adversely about the decisions made by a sitting magistrate. The law provides for appeals during the hearing of a matter against decisions made by a magistrate, and clearly that is an option available to the prosecution. In this case, the Vice President, who holds not an insignificant amount of power in the country, decided to attack the magistrate and the decisions she had taken. I think the ultimate distress came when the Attorney General, reverting to the Konoko case, decided that he was going to refer Justice Prasad, or he said the option to refer Justice Prasad to the Judicial Service Commission because of a decision he made is frightening in all aspects. If you think about it as a sitting average citizen, here you have the Attorney General not only expressing his displeasure with the outcome of a case, not only going on to attack the judge and his competence, but saying that, look, we will take this judge to the Judicial Service Commission because we are unhappy with a decision. That is a clear shot across the bow of every judge. And given that we've had the largest single admission to the bench recently, this is cause for grave concern. We can only hope that the Ghana Bar Association has taken note and that our colleagues in the Caribbean have taken note of what has now become a standard practice.